While time will not permit us to recount that history here, it is fair to say that the government's creation, acquisition, and use of corporations has been cyclical. It increases during times of crisis, and it is followed by periods of reform. The first widespread use of government corporations came during World War I, and other large increases in this form of government action came during the Great Depression and the Second World War. Periods in which government corporations rapidly proliferate generally lead to periods of retrenchment and reform. The most notable period of reform came at the end of World War II. At that time, there were, by one count, 58 government corporations with total assets of approximately $30 billion in 1945 dollars. In response to the largely uncontrolled growth of government corporations, Congress enacted the Government Corporation Control Act, which both dramatically cut back on the number of government corporations and increased the transparency and accountability of those that remained by imposing various budget, audit, and debt management practices. In the years that followed, the government both created new corporations, such as ComSat and Amtrak, and from time to time became involved in private corporations. Perhaps the most prominent example of the latter was the government's takeover and reorganization of the freight railroad system through the creation of Conrail. Through this long history, the government's involvement with both government-created and government-controlled corporations took on many different characteristics. The government appointed some or all of the boards of directors of these entities. Some were designated as agencies of the United States, while others were expressly designated not to be agencies or instrumentalities of the United States. Some were owned or controlled entirely by private parties, while others were owned or controlled primarily by the government. And when Congress created or authorized federal corporations, it expressly established whether laws such as FOIA, the APA, and the Government Corporation Control Act applied. The point of all this is that there has long been a blurring of the line between public and private entities in this country. The basic regulatory model has often been adjusted as government involves itself in corporate entities. But while this involvement has been the subject of great variation, the characteristics and obligations of any particular corporation and the relationship of that corporation to the government itself were, so far as I can tell, universally the subject of careful consideration by Congress, and it has always provided detailed legislation on the subject. Then came General Motors and Chrysler and AIG and others. In the interest of time, I will focus just on GM, which is of obvious interest to me. The vehicle for the government's takeover of GM was, of course, the TARP, which authorized the Secretary of the Treasury to purchase troubled assets from any financial institution. That is the authority that the government used to inject nearly $50 billion of money into General Motors, because Congress created a broad enough definition of financial institution that the Secretary of the Treasury was able to reach a determination upheld by the courts that General Motors was in fact a financial institution within the meaning of TARP. On the basis of that authority and precious little else, the government injected $50 billion into General Motors, required GM to go through bankruptcy, fired the CEO of General Motors, converted the vast majority of this investment into equity, thereby freeing GM of the obligation to generate cash to repay its obligations, determined that the appropriate government ownership of General Motors was precisely 60.8%, and that the UAW Healthcare Trust should own 17.5% of General Motors, and secured the right to name 4 members of General Motors' board. And my point for today is not whether this is good or bad public policy. It's certainly the subject of a lot of debate. But for those who care deeply about the legitimacy of governmental exercises of power, I would offer 2 very important observations. First, all of this was done on the thinnest of legal reeds. The exercise was not the subject of debate and lawmaking within Congress of the sort that has traditionally been the basis for government involvement in corporations. Indeed, when Congress considered a rescue of the automotive companies late last year, it rather clearly declined to pass such a law. It was only after a bill cleared the House but died in the Senate that the executive stepped in to use TARP. And the decisions the executive branch made were wholly unguided by anything but its own determinations of good and bad policy. We heard Judge Ginsburg last night talk about the demise of the non-delegation doctrine. One can hardly imagine a clearer example of a raw exercise of government power with no discernible standard in law. By what standard did the administration act? None but its own judgment about what best served its policy and political aims. For this purpose, TARP was literally a blank check. So to the extent this panel was asked to discuss the implications of a new model for the public-private partnership, there's simply no model at all. The model is whatever the executive decides suits its purposes in the moment. Second, looking forward, there's absolutely no guidance in law for many questions that might arise from the government's ownership of 60.8% of General Motors. How should the government manage its stake in GM? What are its rights and duties going forward? What are the government's appropriate goals? Is it interested in getting out of GM as quickly as possible, or should its goal be to maximize the taxpayers' recovery of their investment? How does the government's ownership in GM and Chrysler impact its regulation and interaction with competitors of those enterprises who didn't receive government money? Is the government obligated to treat those companies even-handedly, or may the government favor the companies that it has decided to own? Even if it pledges even-handed treatment, what checks should be in place to ensure such treatment? How transparent should the government be? How transparent should GM be? Is GM permitted, as it appears to be poised to do, to spend U.S. taxpayer money to fund its businesses in Germany, Brazil, and China? The government has, of course, attempted to answer many of these questions, but again, the answers are not in any way guided by what we would recognize as the rule of law, and certainly do not bind the government. Shouldn't the taxpayers' investment of scores of billions of dollars be controlled by legally binding rules developed through the Constitution's lawmaking process? I would close simply by saying this. If the new model for public-private partnerships is the open-ended and unguided example we see in the automotive industry, the implications for the administrative state are extreme. The structures, principles, and rules of law that have long been developed and applied would be replaced by extreme deference to the executive that says, trust me to make the right decisions and do the right things going forward. Now, I'm all for a robust executive within the structure of our government. This approach, however, rewrites the structure in ways we should not countenance. I think it's incumbent upon Congress not simply to observe, report, and cajole, often on a representative by representative basis, but rather to make laws to guide this investment going forward. I think that's the model that we deserve. Thank you.